We hope you enjoy listening to this podcast of St. Louis on the Air, brought to you by University College at Washington University, with undergraduate and graduate programs part-time, evening, and online. University College at Washington University, offering world-class education within reach.
Welcome to St. Louis on the Air. I'm Don Marsh. All eyes in the legal world and beyond are in Washington these days, and the drama being played out in the Supreme Court nomination process for Brett Kavanaugh. Our Legal Roundtable panel will take a closer look at that process and at a lot of other things going on in the world of law and jurisprudence. Joining me in studio are Bill Freivogel, Professor of Journalism at Southern Illinois University in Carbondale. Mark Smith is Associate Vice Chancellor and Dean for Career Services at Washington University. Rebecca Hollander-Blumoff is Vice Dean for Research and Faculty Development and Professor of Law at Washington University's Law School. Thank you all so much for being with us.
Thank you.
Thanks.
Where do we start? There is so much going on in this Washington deal. Rebecca, I'm going to start with you. I'm curious as to what your impression is of bringing in this female prosecutor to question Mr. Kavanaugh or Ms. Ford or both. I'm not quite sure tomorrow.
Yeah, at the moment it appears as though she's slated to question Dr. Ford. It's not clear to me whether she's going to be questioning Judge Kavanaugh. I think given her experience and some of the statements that she's made in the past, she seems like she will be a pretty good questioner optically for the Republican Senate delegation on the Judiciary Committee.
You mean the 11 men who aren't going to ask any questions?
Yeah, if you
11 white men?
Yeah, if you can get past the optics of them having to delegate to someone who they called a female assistant, once you get past that, I think in the role she's likely to play pretty well. The question might be, can you get past that?
Right. Bill, what do you think?
Well, I mean, this is just, it's probably a smart tactic by the Republican senators to try to avoid the appearance that was given back in the Anita Hill Clarence Thomas confirmation hearings, what was all white male senators challenging her truthfulness and whether she was fantasizing about Clarence Thomas, etc. I was my wife and I covered the Clarence Thomas Anita Hill story. Margie wrote about the Anita Hill portion of the testimony in Clarence Thomas's rebuttal about it being a high-tech lynching. And I was reading some of those stories over last night, and it's the Republicans may this time may be avoiding some of the mistakes that they made last time, but there's some It seems like the storyline is proceeding a lot like it did then, with this sort of rush towards judgment. The Republicans not wanting to give enough time for testimony of witnesses, other women who had said Clarence Thomas had sexually harassed them were not allowed to testify. So it seems to me the Republicans this time around are doing the same. How can they not call Kavanaugh's friend Judge, who was supposedly in the room at the time of the sexual assault of Dr. Ford? And I also think they're making a mistake not to have the FBI do a investigation of these various incidents. As a matter of fact, if you back then, it was the FBI investigation of Anita Hill that they used as their main way to knock down her credibility. They said, "Oh, you didn't tell the FBI about all these details when the FBI talked to you. You're making them up. Slick lawyers have given you all this stuff." So I think maybe even from their own vantage point, they're making a mistake. But I definitely think they should have had the FBI do an investigation.
But Mark, this is quite different than the Hill case. Hill was a question of verbal assault, basically. This is a question of sexual assault.
Yeah, and also a much younger. I mean, they were adults when that happened with the Anita Hill thing. One of the things I think about Mitchell that's going to be very interesting, and Rebecca mentioned this before we came on the air too, is that she has talked about the fact that children.
She's the prosecutor.
The prosecutor. There's going to come. She's talked about the very common misconception that when children will talk about abuse. And this woman was, I think, 15 at the time. And she says, people think that children would tell right away and that they would tell everything that happened to them. In reality, children often keep this secret for years, sometimes into their adulthood, sometimes forever. And so her typical role is coming in, going after the abuser and probably being really tough on the abuser, but with the victim, who's the witness who's coming forward, to be more kid gloves. So I'm not sure how she's going to do it in this hearing. Is she going to kind of switch roles and be harsh with this woman? I think that could be a real mistake, optic-wise, and I'm very curious to see what happens with this.
Rebecca, you're shaking your head. The Democrats also get a chance to ask questions.
Yeah, they sure do. They sure do. I mean, I can't see Mitchell coming in and being very harsh and prosecutorial with Dr. Ford, in part because I think so much of what is going on here in this hearing, at least at this moment in time, is really not for the senators themselves. It's for the American people who are watching, right? It's meant to suggest that the senators are listening, that they care, that they want to hear this, that they want to get to the bottom of it. It's meant to give the public a perception that there's really been a full vetting. And yet at the same time, you have pretty clearly Republican leadership talking in terms that suggest no such thing, right? You've got Mitch McConnell saying, we're going to win. Right? Yeah. And we're going to win is not about we're going to have a collaborative process where we get to the bottom of what happened and we're going to try to figure it out. It's this is a vote count. And so maybe beyond the hearing being for the American people, it's for maybe 2 or 3 senators who are on the fence. But the optics matter a lot here.
Big time.
And I think this fact that this hearing is not a trial. You know, you keep watching on TV and everyone keeps talking about, or I hear my neighbors talking about, well, where's the presumption of innocence? I mean, this is not a criminal trial. This is more like a job interview. And
big promotion.
Yeah, a big promotion. And you have to show that you have the ability and I would say the character that would warrant you having this big promotion that you're going to get to keep for the rest of your life. Some people would disagree with the way I view that. But it's definitely not a criminal where somebody's going to be found innocent and somebody's going to be found guilty.
You know, President Trump, after controlling himself for a few days, was trashing Debbie Ramirez, the Yale student who had accused Kavanaugh yesterday, and saying, why didn't Dr. Ford or her loving parents report this 30 years ago, which, as people have said before, ignores the fact that victims of sexual assaults often don't report them at the time that they occur. I think that the president's fall and Mitch McConnell are falling into that sort of trap that they were avoiding at the beginning of trying to make the women look like liars.
Do we know how much time the lawyer is going to have to interview Dr. Ford?
I thought I read 5 minutes per senator, so I would assume she'd get that whole time.
She'd get the 55 minutes then, and each of the Democrats would get 5 minutes to talk. That's
what I assume, but I don't know that for a fact. I also think the Democrats might be well served to have a lawyer asking their questions, just because they tend to grandstand, and if you're asking questions, you should be asking questions, not testifying yourself.
They've got Kamala Harris, and she's a former attorney general and pretty good lawyer, apparently.
Yeah. I mean, let's make clear that I don't believe the Senate Judiciary Committee has ever had a lawyer asking questions of witnesses in connection with a Supreme Court confirmation report. This is just a new procedure that was invented for this situation, so there was a woman out there instead of a bunch of white men asking the questions. Well,
maybe they need training then. I mean, the Democrats, if they're not going to bring in, but I mean, this grandstanding stuff, I just don't think it serves them well. I
mean, it's certainly true that a lawyer with the right skills can draw out a narrative in a much clearer way than a lot of senators barraging at 5-minute intervals. Taking it out of this particular situation, there might be something to be said for reexamining the process anytime you're trying to actually get a real story out.
I mean, that's true. The senators are terrible at asking questions. Almost all of them are terrible. And I mean, it was, Mitch McConnell pointed out that during the Watergate hearings, oftentimes they did use the lawyers to elicit most of the testimony. So it's not that it hasn't ever been used on Capitol Hill. It's just that it hasn't ever been used in this kind of situation before.
Rebecca, you point out that this is all to play to the American public. I think we have to keep in mind that 51% of the American public is female. And that too is an audience being played to and watching very closely.
I think that's right. I mean, and obviously that's not a monolithic group. That's not a group that all votes in the same direction or has the same reaction to these allegations. But I think it's certainly true that there are a lot of women who have been very galvanized by, this in the context of the whole Me Too movement, and it's really changed the way that a lot of women, I think, are approaching the political system and their engagement with it.
And you've had this kind of thing happen to them in the past and said, okay, I'm not going to. But the fact that somebody else is coming out and people are saying, oh, she's just making this up because of whatever reason, I think for so many women, it's just like, what are you talking about? Why would anyone bring this upon themselves?
And I think, in light of some of the other current events of the day, for example, Bill Cosby's conviction and sentencing, you can see that it's long been in the playbook to issue a blanket denial in a situation where what comes out later is, beyond a reasonable doubt that this did happen, despite a denial.
I've got to take a break now, but perhaps the two most important women watching all of this will be Senators Collins and Murkowski. They hold a big key, no question about that. Okay, let's take our break. We'll come back and continue this conversation. There's more to talk about, and we'll do that when we continue. This is St. Louis on the Air on St. Louis Public Radio, 90.7 KWMU. Now back to our conversation with attorneys Bill Freivogel, Mark Smith, and Rebecca Hollander-Blumoff. Bill Freivogel, I'll come back to you. There is a new wrinkle in the case as of this morning. Michael Avenatti, the former St. Louisan, has produced yet another woman who claims to be a part of these scenarios, the kinds of scenarios we're talking about. This woman apparently was a rape victim, and she places Brett Kavanaugh at the scene of one of these, unclear as to whether or not he was a participant. What does this do to all of what we've been talking about?
Yeah, it seems as though she doesn't say that he was one of the participants in her being raped. So this is a woman whose name is Julie Swetnick. She's had she grew up in the same part of Bethesda. Actually, she lived in Gaithersburg, just a little bit north of Bethesda, but basically in the same high school scene that Kavanaugh and his friend Mark Judge grew up in the Bethesda area. And she's filed an affidavit in which she says that she attended a number of parties, knew that Judge and Kavanaugh put grain alcohol in the drinks of especially vulnerable female attendees, girls attending the party, who were then put off in rooms where a train of men that included Judge and Kavanaugh would then line up to basically rape them. She said that she herself was a victim of some of these rapes, although she doesn't specifically say that Kavanaugh or Judge did that to her. Kavanaugh said this is Twilight Zone stuff, didn't happen. The president has said that Avenatti is, he knows it's just a liar. From his own personal experience, since he was the lawyer representing Stormy Daniels.
Rebecca, does she have to appear before this committee now, would you think?
I think the stakes are going up for a broader investigation and to bring more witnesses in, either in front of the Judiciary Committee or to have the FBI start doing some interviews. I think especially the stakes have gone up for Judge. The friend Judge. He is holed up, I believe, on the Delaware shore, hiding out to avoid being involved in this. And I think as these stories come out, the idea that we wouldn't hear from him directly under oath becomes more and more impossible to imagine in terms of having an outcome that people really would feel was legitimate.
He's hiding out, but not too well, because he's been found. So there's that. Mark, this latest thing, the Avenatti statement that came out today, this was a sworn statement that this woman has made. That's a little bit different. Isn't she in some legal jeopardy if she is lying in a sworn statement?
Yeah. I mean, she could be, I guess, for perjury, but, it's not like she's lying to the FBI where it's a felony if you do that. So I think there's more weight to it. And, this is an interesting question. I assume they're going to be sworn in tomorrow before.
Sure.
Yeah. So then we get statements. I also think putting things in writing, you've got less wiggle room. So I think it's more serious. But the thing is, it's like we've talked about before. This is really, in many ways, this is not a legal issue. This is a political issue. And I think the two sides are looking at it from, the Republicans are saying, how hard can we push this and still not hurt ourselves in the midterm elections? And the Democrats are saying, how far we can push this maybe to convert those two Republican senators who we think we might be able to get. But it's not a legal proceeding.
Yeah, there's no legal standard like probable cause or beyond a reasonable doubt or preponderance of the evidence. It's just, what do we think?
Or even a procedure. They're just making up the rules as they go along. We're going to allow this witness. We're not going to allow this witness.
And this procedure differs from the procedure they used before with Anita Hill and Clarence Thomas. It's just at the end of the day, it's does the Senate think that this person has the character to be put on the highest court in the land? That's what the standard is.
Do you have any feeling, Rebecca, on that with regard to the nature of the statement she signed?
I think it's possible that given the declaration, she might be subject to some kind of prosecution. I think regardless of whether she signed this statement, as a sworn declaration or not, she still would be subject to a defamation case. Yeah, that's a good point. And so if she is lying and, others accusers are lying, whether they say it to the press or they say it, on Twitter or they say it in a sworn statement, if it's truly untrue, then they could be the subject of some kind of defamation action. I haven't heard Judge Kavanaugh suggest that yet. Yeah. I know that's something President Trump suggested in accusations against him. So that's possible out there.
And defamation would be a tort action. It's not a criminal thing.
It's civil.
But does this statement carry more weight than a simple declaration from Dr. Ford, for instance?
I think it carries more weight than just Ford's interview with the Washington Post. But I think that Ford's testimony in person tomorrow will carry more weight than this affidavit.
Right. I think that's right.
Okay.
And I'd like sworn testimony to the FBI because they'll prosecute you then.
Well, as Rebecca indicated, that may be closer than it has been.
I mean, now there are a bunch of witnesses to these three different allegations who could be who could be interviewed by the FBI. All the people who were present at Yale and Lawrence Hall Common Room involving Debbie Ramirez, the people whom Ford talked to, the person who gave her the lie detector test, what those results showed, Mark Judge, other people who were present at these parties that the third accuser is talking about.
And I want to add, from what Bill was saying, in terms of the character issue, I think that Judge Kavanaugh has raised the stakes on that somewhat by the defense that he's staked out. I understand that he's now saying, I'm not perfect, nobody's perfect, but in the interview that he did on television, he really staked out an approach that described him as, a service project, nose to the grindstone.
Go to church.
Only legal drinking, no sexual activity, kind of a character. And so the more the tide rises on the other side of that, the more he has a character problem that in some ways is a little bit of an unforced error on that point.
Anything else to add on this? I'd like to move along to some other things Washingtonian.
I'll just say one thing that's different now than Anita Hill, Clarence Thomas is it seems like at least some initial polls, an NPR poll, not a majority, but more people believe Dr. Ford than believe Kavanaugh, like 32 to 26%. Back then, more people believed Clarence Thomas than believed Anita Hill. One thing that unfortunately hasn't changed, I'm sorry to say, is Senator Danforth's seeming continued focus on how horrible this is for the guys who are accused. He didn't look good. In a wonderful career, he didn't look good in what he did with Clarence Thomas, and he doesn't look good this time either. A bunch of clergy have criticized him for that.
Sure. Okay, let's look at some other things. And I wonder, Mark, I'll start with you. Is the Mueller investigation in any jeopardy now that Assistant Attorney General Rosenstein looks like he could be on his way out as early as tomorrow?
I think it's always been in jeopardy. And, typically you would say, no, it's not. It seems like if we were betting on it, I would say I don't think anything's going to happen until after the election because I think it's too risky. But, this is up to the president. He seems to make decisions pretty quickly and shoots from the hip. And so, I could see Rosenstein getting fired and Sessions quitting, and he puts somebody else in until they get rid of Mueller.
I'm glad you mentioned the election because I had the opportunity recently to talk with the former director of the FBI, James Comey, and I asked him if, in fact, he thought that Mueller could be through by Election Day, and here's how he responded.
I know it's been incredibly productive. In just over a year, it's produced all kinds of charges and convictions. And so they've been working really hard and produced a lot of results. But I don't know. I think there's an argument to be made that the conviction, the plea and cooperation by Paul Manafort may represent that we're in the fourth quarter because the way you normally do investigations is you work from the bottom up. And so they're getting pretty high. But again, the reason I'm hesitant to even say that is Bob Mueller has conducted his investigation like a pro. You know nothing about it except through his public filings, and that's the way it's supposed to be. So I can't say with certainty where he is.
Former FBI Director Jim Comey, that fourth quarter comment got a lot of attention. I think all of the cable networks, The Hill in Washington responded to it. Even The Onion, if you will, had some reference to it. So a lot of people were paying attention to that, Bill. What do you think? I mean, do you think this could happen before Election Day? Should it?
I guess I think it probably won't happen before Election Day, but maybe pretty soon after Election Day, which would still have us being in the fourth quarter. I mean, I totally agree with Comey. I have a lot of respect for Comey, and we have to remember that it was Trump's unforced error of firing Comey that led to the special prosecutor and the whole situation he's in, and bolstered the case for obstruction of justice on his part. But I think with Manafort turning, Cohen having turned, that we're getting down to the end. If I were Mueller, I would have a draft of my report written already and be ready to just to unload it before I got fired.
Yeah.
I don't know if Mueller is such a by the book guy. Maybe that wouldn't be by the book, but I have read. I believe that he's been working on some drafts.
But he's certainly a sharp cookie, and he's got the thing structured in such a way that if this falls apart, there's still some state charges that could be filed, and that's big. That's really a firewall for him.
Yeah, and he's done a lot of work, too, to connect up with relevant U.S. attorneys' offices across the country to farm out pieces of this that are of particular interest to those groups, that are maybe offshoots. So I think he's planted a lot of seeds out there to make sure that something's in place. My own feeling is I don't think he's going to get fired, but I'm not a gambler.
You don't think Rosenstein's going to get fired? Or be forced to quit?
Mueller.
Oh, Mueller.
Yeah, I don't think that it's going to come back to Mueller being kicked off this investigation. I think that just politically that firestorm is too great. But who knows?
Well, the president is so mercurial. I mean, there's no way of even trying to project what he could possibly be thinking with regard to Rosenstein. I mean, he would sure like him out of there. I don't think anybody's going to deny that. But what is he going to do? And they meet tomorrow.
I mean, I think the main reason for Trump to keep Rosenstein in would be that Rosenstein now he's injured. He's damaged goods because of the New York Times story. And so why not leave him in there as damaged goods and not have to deal with the political fallout of firing him? So, I can see Trump saying, well, we'll just play this thing out till after the election.
My wife and I were talking about this. And the thing is, you feel sorry for this guy because here he is, a lifelong public service who could go to a large law firm and probably make 5 times as much money, not have to worry about all this stuff. And he's plodded along, doing the right thing, just being exceptional. And then he's got to deal with all this kind of stuff. And it's just like, really? I mean, I think if I were him, I would just say, screw it. I quit. I'm going to go make some money.
I'd really like to see the story someday written about the New York Times sources on that story.
Yeah.
And, what was their – I mean, as a reporter, when you're using anonymous sources, you're supposed to pay attention to what are they trying to gain. Yeah. Of course, if the information's so great, you oftentimes will publish the information even if you know they're trying to gain something that may not be terrific. But I don't know what were the sources they're trying to do. Were they trying to get Rosenstein fired because that would help the Democrats? Or I just have no clue.
Yeah. Very quickly.
One thing I just want to add, picking up on Mark's point, is that it would be a lot better for President Trump if Rosenstein resigns, because the Federal Vacancies Reform Act actually limits who Trump can put in that role, depending on whether he's fired or if he resigns.
Really? It would be the Solicitor General if that, in fact, happened. I have to take a break. We'll come back. We'll have more of this and other things, too, in a moment. This is St. Louis on the Air on St. Louis Public Radio, 90.7 KWMU. And welcome back to the Legal Roundtable panel of Rebecca Hollander-Blumoff, Mark Smith, and Bill Freivogel. Mark, I'll turn to you. With all the things we've been talking about, we almost forget it's almost the first Monday in October when the Supreme Court convenes. Should we be paying more attention at this point?
Yeah, Rebecca was just saying during the break, we get a whole other set of cases released tomorrow. But there's 2 cases that I wanted to just mention. Death penalty cases, one out of Missouri, and I think we've talked about this before. The person has a medical condition, and he says the injection protocol would cause him basically to drown in his own blood, and so he's asking for a different type of execution. Probably, it's a local case, but the legal issues are probably not as interesting. More interesting is another case, I think it's out of Alabama, where the man who was convicted of murdering a police officer has since had a series of stroke. He's basically in a wheelchair, incontinent, doesn't know who the president was, doesn't remember the murders. And the question is it cruel and unusual punishment? To go ahead and execute this guy who doesn't even know what he did, what's the purpose, and is it cruel and unusual punishment? But there are a bunch of other cases we were talking about. But
what's caught your eyes, guys?
I think a case called Gamble is particularly interesting right now. It's a case that involves the double jeopardy clause of the Constitution. Technically, the issue is whether the double jeopardy clause in the Constitution should apply to the separate sovereigns doctrine. The idea here is that if a federal prosecution takes place and a state prosecution takes place for the same conduct, that's historically been considered to be acceptable. But the question here is, should that be allowed? If we get rid of the separate sovereigns doctrine, it's not the case that we would necessarily get rid of dual prosecutions for all kinds of conduct that was similar. There's a rule from 1932 called the Blockberger rule that means that as long as crimes have elements that are different from one another, that each crime has a different element, that you could still prosecute in a federal and a state situation. But that would bring down a lot of litigation on a very old precedent, the Blockberger precedent, if we get rid of that separate sovereigns doctrine. This is a case that is a little bit of a strange bedfellows case, I'll say, because there was a recent concurrence in a case a few years ago between Ruth Bader Ginsburg and Justice Thomas, who both urged for reconsideration of this doctrine, urging that we get rid of it. The why is particularly of note to us today, maybe rather than just kind of an esoteric question, is that But some people have suggested that this is of particular relevance in some of the prosecutions that we have going on right now where President Trump might invoke his pardon power. So a case like Paul Manafort's, where if we have a prosecution in the federal court and the president pardons the defendant, typically this right now under the separate sovereigns doctrine, you could have another prosecution in the state, and if we get rid of that, that would be a dead case.
Yeah.
Bill, anything you want to talk about before we move on?
We shouldn't forget the Mississippi gopher frog, and whether or not who's on the Endangered Species Act list, and whether or not the federal government can grab some Weyerhaeuser timberland in Mississippi where that frog used to live back in the 1960s in order to try to create some habitat for the Mississippi frog.
Okay, we'll have to look for that.
Yes, that's the first case. That's the first case coming up on Monday.
We have one of our listeners is asking, what's the legal definition of slander and libel, and how would it apply to the circumstances surrounding Judge Kavanaugh's confirmation hearing?
Well, if the person who is libeled or slandered, in other words, their reputation is defamed, if they are a public figure or a public official, as Kavanaugh would be, it's actual malice, means reckless disregard for the truth, knowledge of falsity. It's a pretty high standard.
Right, and the difference between slander and libel, just to remind everybody, is slander is verbal and libel is in print.
Right. Okay, I want to play another clip for you and then move along to some other things. Again, another clip from the former FBI Director James Comey. I'm interested in getting your feedback on what he had to say about President Donald Trump and basically his rule of law thoughts. Let's go to that.
I think we're in two different places. We're in a place where the President of the United States relentlessly attacks the rule of law and the institutions of justice. So that's terrible. But the second place we're in is that Americans have awakened to the importance of the rule of law and the danger posed by its erosion. And that's a very, very important sort of antibody response, and it's a source for optimism. People who would otherwise not spend a lot of time thinking about it are now thinking about why this matters so much, that these institutions not prosecute people because of politics, not protect people because of politics, and that they stand apart from the political and seek only to find out what's true and what's just. I think everybody's coming to understand that, in a way provoked by the attack.
Rebecca, do you share his optimism?
You know, I think that the unprecedented amount of political activity that we have seen is a cause for optimism on the front that Mr. Comey is talking about. You know, I think he's absolutely right that people care deeply about the rule of law. I think that's part of why there's so much focus on the Supreme Court right now. The Supreme Court, if you look at social science, the Supreme Court is the branch of our government that enjoys the largest perception of legitimacy. And people really want to believe in it. They want to believe in the rule of law. And so attacks on the federal judiciary, I think, really hit in a particularly hard place. And that's part of why you see that there's so much at stake in this fight.
I think he's definitely right that we've never had a president so much at war with the rule of law. I mean, keep in mind that this deep state of FBI and Justice Department officials, I mean, when he's talking about Sessions and he's talking about Rosenstein, these are people he appointed. And to have a president, after a federal prosecution gets a conviction of Manafort, to say how sorry he is that his prosecutors won a conviction, and to hear him talk about how prosecutors shouldn't ever be able to flip people because they're flipping people against him. But that's what federal prosecutors have done forever. So I mean, you would never know if you didn't have confirmation that he was president of the United States.
Okay, I'm going to do what we might call a lightning round now because we don't have a lot of time left. You're familiar with the case of the gay married couple that was denied the ability to stay in a retirement center. They have filed suit. No surprise there. Anybody have anything to say about that?
Well, it's a big question of whether or not sexual orientation, discrimination against sexual orientation is protected by the Missouri and the federal laws that bar discrimination on basis of sex. two federal courts of appeals, the Second Circuit and the Seventh Circuit in Illinois, have said that discrimination against sexual orientation is covered by Title VII, the federal law against sex discrimination. One federal court of appeals, the 11th Circuit, has said otherwise. There's a case before the Missouri Supreme Court and the 8th Circuit Court of Appeals here in St. Louis on that very issue. Probably it will go to the Supreme Court. Probably one of these cases will go to the Supreme Court for a decision at some point.
All right. The next issue I have on my folder here is the duck boat suit. We remember what happened there in July in Branson. 17 people, I think, were killed in that. But what's interesting to me is that Josh Hawley, our Attorney General, has filed a suit here. And he is suing in this case. Other suits have already been filed by some of the relatives of the victims here. Do these two suits get in the way of each other, Rebecca, do you think?
I don't think they necessarily get in the way of each other. I will note that in the suit that Hawley brought, the defendants have responded asking for dismissal based on the fact that this is covered by federal law. The Coast Guard governs this, and they suggest that therefore he can't pursue this suit because this is completely governed by Coast Guard regulations. He's framed his suit as under the Missouri Merchandising Practices Act, so I think it's an interesting question whether he'll be able to get around that. In terms of whether it detracts from the tort suits, I don't think so.
Is Hawley running for office?
Last time I checked, I think he was. Yes, very much so. I do believe, yeah. Okay, moving right along. There have been a couple of suits filed in connection with the protests that followed the acquittal of the police officer Stockley. The most recent one, just I think yesterday, was Alderman Megan Green has filed suit. Basically, she was interrupted on her way home from an event and was tear gassed. But she is not filing for money. If she gets any, she'll give it to charity. She's doing it to change policy. Is this the way to change policy? File suits like this?
Well, I think these lawsuits may change some policy. I mean, as you say, there are a number of lawsuits. The one right before Green's lawsuit was Arch City Defenders on behalf of 12 of the protesters there. A Post-Dispatch photographer has a lawsuit. There was an earlier ACLU suit, which is being mediated right now to try to actually change the policy. I mean, this was the third night of protests. It was that whole kettling thing where they surrounded protesters, wouldn't let them out. Those protesters had not been connected with the window, the breakage of windows nearby. These were deplorable police tactics where they basically closed these people in and used tear gas in their faces.
When they were down, spraying them. And in that case that you're mentioning, Judge Perry issued the preliminary injunction to stop these tactics, but...
Yeah, I think it's a mixed bag on the history of the court in terms of being able to change police policies. Sometimes it works and sometimes it doesn't. You know, a notorious area where it hasn't worked is in the case of chokeholds, which have been litigated over and over and just has not been able to change police policy. But it could work, and there are situations in which it has. I think it's a multifaceted approach that needs to happen.
Right. A little over a minute left. Very, very quickly. Mark, very quickly, Kim Gardner's exclusion list. What do you make of that?
Well, I mean, I think my sense is they've had these in the past. There have been particular officers where they say, we're not going to do that. But the fact that nobody seems to know who's on it or why, and we've got retired officers, it just doesn't seem like it was handled well.
Should the names, Rebecca, be publicized?
I think that's a really tough question. Yeah. You know, I think there's so much involved in that. I think the point of the rule, very similar to what we have in the criminal law, the exclusionary rule, it's meant to incentivize certain behavior and discourage others. Whether you publicize the names of these particular officers, I think that's a very tough question, especially in this current climate where we have a lot of outing on the internet and a lot of crowd action against individuals. I think it's very difficult.
And this is being litigated, and it would probably be an exception to the Sunshine Rule because it deals with, one would say, personnel issues.
Yeah. And a number of cases, Bill, in 30 seconds, have already been disrupted by this.
They have, maybe a dozen. Yeah. I think she mishandled it, and I think the names should be public.
Everybody's talking about these things in Washington, and it's great to have the opportunity to do it with three attorneys. So I thank you all. Rebecca Hollander-Brumoff, thanks for being with us once again. Mark Smith, great to see you once again, as always, and Bill Farvel, same to you. I'm Don Marsh. This is St. Louis on the Air on St. Louis Public Radio, 90.7 KWMU.
Support comes from Missouri Forest Products Association, committed to sustainable and sound conservation of the state's forests, which support more than 41,000 Missouri jobs, resulting in a $10 billion industry. ChooseWood.com.